Hello, everybody. Good evening. Actually, now I am trying to mention about I'm trying to proceed with the place I stopped. Actually, I must mention about something more about the 4B subject in the Constitution of Democratic Socialist Republic of Sri Lanka's Constitution's fourth article and subarticle B. It confers the executive powers to the President of the Democratic Socialist Republic of Sri Lanka and not anyone else. And I must mention, according to that provision, he or she is the leader of the country, and also he or she is the leader of the government, and also he or she is the leader of the cabinet, and also he or she is the leader of the he or she is the army commander. That means all the not only army commander, military commander, because army, navy, air force, all the three forces are under the executive president. And the most important thing I want to tell is that only one person in this country who can declare the peace or war is the executive president of the Democratic Socialist Republic of Sri Lanka. Neither prime minister nor any other minister or no any other person could be able to declare peace and war. Therefore, everybody should know that point, because if someday some person other than the executive president of the Democratic Socialist Republic of Sri Lanka make such a thing, just in legal terms, if some person, as an example, if prime minister of a Democratic Socialist Republic of Sri Lanka signs a ceasefire agreement, that agreement has no value at the time of it's been signed. In legal terms, it's void ab initio. No value, void ab initio. Like in Sri Lankan history, there are two times where such things were happened. Firstly, in 1994, Prime Minister signed the ceasefire agreement, even though the president is already been there means president is already in the country, and also president is totally capable to do his work. And the second time, in 2001, the prime minister signed the ceasefire agreement on behalf of the country, but he has no any authority to doing so. Therefore, all those two documents are void ab initio in In legal terms, void ab initio means at the time of doing that thing, at that time it's been null and void. Null and void. But luckily means not luckily for the country, but luckily for the both prime ministers, nobody went to the courts to get a writ of quo warranto. If somebody went to the court and get a writ of quo warranto, they had to be a very big trouble, because quo warranto means in simply, what is your authority to do something like this? That is the simplicity way of explaining quo warranto. Quo warranto is no power, no authority existed to do such a thing. Therefore, but no person went to the courts. Due to that reason, both those prime ministers were so lucky, and that's the importance of the Article 12 sub-article 4 of the Democratic Socialist Republic of Sri Lankan Constitution. Then another few minutes or few hours I will come to the other areas of the Constitution. Good luck. Thank you very much. I am Pathum Vikramaratne, attorney at law.